Judge lets state law claims continue in AI voice case. A New York federal judge has ruled that a case involving two actors who claim their voices were cloned for generative artificial intelligence, Gen AI narration software, can proceed with their state law claims. However, the judge dismissed the plaintiffs' federal trademark claim and most of their federal copyright claims. Plaintiffs Paul Lehrman and Linnea Sage claimed in a class action complaint in 2024 that Gen AI startup Lovo stole voices to create millions of voiceover productions without permission or proper compensation. According to the complaint, the voiceover industry is estimated to generate more than $2 billion annually in the United States and more than $4 billion annually worldwide. As the complaint notes, voiceovers, commonly known as narrations, are integral to various industries, spanning entertainment, advertising, marketing, education, and other corporate sectors. They serve as indispensable tools across a wide array of mediums, including film and television, commercials, animation, audiobooks, e-learning, corporate presentations, marketing presentations, educational videos, interactive voice response, IVR systems, podcasting, video games, documentaries, virtual assistants, public announcements, dubbing, radio imaging, audio dramas, museum exhibits, phone systems, language learning, medical narration, corporate training modules, websites, sales pitches, and digital content. They are even used in venture capital funding pitches. Traditionally, actors are hired to read scripts and are paid a negotiated amount for the use of their voices, often including royalties or residuals. Lovo says it's trying to disrupt the narration business by selling a text-to-speech subscription service that allows its clients, typically companies, to generate voiceover narrations at a fraction of the cost of the traditional model. The plaintiffs claim they were tricked into providing voice samples on the Fiverr freelancing platform by people they later learned worked for Lovo. According to the complaint, on its website, Lovo represents to potential clients that it has agreements with actors allowing Lovo to utilize those actors' voices and compensating them appropriately for that use. That may be true with respect to some actors, but it is emphatically not true with respect to plaintiffs. Lovo had no permission to use plaintiffs' voices for training its AI generator, to promote the Lovo service, or to market voices based on plaintiffs' voices. And Lovo never compensated plaintiffs for any of Lovo's unauthorized uses of plaintiffs' voices. Lovo called the complaint a tale filled with pathos and the woes of artificial intelligence, and argued that Fiverr's terms of service granted copyright licenses to platform users like Lovo. The judge ruled that the plaintiffs made cognizable claims under the New York civil rights law, which protects against the unauthorized use of a person's voice. However, the judge dismissed the plaintiffs' federal trademark and false advertising claims under the Lanham Act, saying the plaintiffs' voices do not primarily serve as source identifiers, as they would for a product, and thus do not serve as trademarks. Also, the judge said the plaintiffs didn't establish consumer confusion about the source of the voices. The judge allowed a copyright infringement claim from Sage based on Lovo's use of her voice in public presentations. However, the judge dismissed claims based on Lovo using the plaintiffs' voices to train their Gen AI model. The dismissal of the training claims was based on a failure to explain what training is or how it works, even at a very high level of generality. The plaintiffs have the opportunity to amend their complaint to remedy that failure. As we blogged about last year, a proposed bill in Congress aims to regulate the creation and use of digital replicas of human beings, including their image, voice, or visual likeness. Lawsuits based on deep fakes are likely to increase as Gen AI becomes even better at creating images of human being that are indistinguishable from reality. Questions about intellectual property and AI? Visit us on our website, www.aeonlaw.com. Aeon Law, unleashing genius.